All right, so there's right sua sponte. Most of these, I think, are pretty much self-explanatory. I think if you read through these motions and briefs, it's just going to open Pandora's box, so to speak, to your legal understanding in mind. And I want to comment here again as to what your legal profession has done to you. See, they'll write these legal documents and papers up and try to convince you, that, and you've been told this all your life. Boy, wait a minute, that's a legal document, boy. You better not take any chances. You better take that to a lawyer and make sure that everything is right, boy, because if you don't do that, boy, you could really get in trouble. And you've heard a lot of horror stories, where the ignorant farmer had his house taken away from him or something gone awry because he didn't understand the law. They were doing that back in Christ's time. They were oppressing orphans and stealing widows' houses back in those days. Today we just call that probate. Yeah, call that probate inheritance tax. They're still doing the same thing. Those lawyers haven't changed a bit. They're still stealing widows' houses. But they always do it because the widow is ignorant. What would happen if that widow had some knowledge? What would happen if that housewife knew and understood her rights? What would happen if that housewife or those orphans were to read their constitutional rights and their contract with their government and walk into that courtroom and say, wait a minute, Judge, I demand all of my rights at all times and I don't waive any of my rights at any time, including my right to time, and I demand counsel of my choice. In addition to that, in looking over this information, Your Honor, I find that there are 8 significant federal questions that are being raised here because due process of law is not being afforded me under the common law. I mean, could you imagine some 60-year-old widow, she walks in and says, hold the phone here, I think we've got some issues of rights involved here, that where rights secured by the Constitution are involved, Judge, there can be no rulemaking or legislation that would abrogate them. No, you don't see that happening, but I'm in hopes that you're going to find factory workers and housewives and ordinary people going into the courts to demand their rights, because you remember in Lesson 13, there are 7 rules, and if you'll follow these 7 rules, you'll qualify your case, whether it's a parking ticket or murder, to be reviewed by the Supreme Court of the United States. But you have to follow these rules. Now remember that, okay? Now, if you go into the courtroom and you have some knowledge between your ears and you demand your rights, and you know why you're demanding your rights, that you're not just going in there and mouthing a lot of words that you've memorized out of the book that you don't really have any comprehension or understanding of. But I mean, you're sincerely walking into the courtroom, and I want you to turn over, this is number 17, and this is called your notice and demand for counsel of choice. And number 14, I've got counsel down here. And here you are demanding your counsel. And in addition to the counsel, you filed a couple of briefs. If you'll notice over here, there's also a couple of briefs that I put in here. I don't know just where they are at the moment, but you look them up and you read them. When you read those, and you take a look at your legal quotations at what your Supreme Court has said about this subject of counsel, all of a sudden when you go into that courtroom, you're not an ignorant widow lady who's about to have her house stolen. All of a sudden, you're a knowledgeable patriot who walks in and says, I'm demanding redress of grievance. I'm staking out my 9 square feet on this courtroom floor, and this man that's sitting over here is an imposter. He's not a public prosecutor, Your Honor, and I demand that the court remove him because he's a judicial officer and this court is improperly set. And watch that judge up there, his eyeballs will... Who is this woman who's coming into my court? Who are you? And then he'll say, you better get a lawyer, lady. You don't know what you're getting into. See? And they'll try to threaten and intimidate you. We have ladies here in Boise, Idaho that can go into the courtroom and demand their rights. And boy, if you don't think that's funny, spread stark terror in every courtroom in the county. Okay, I think enough said about that. I'm not going to sit here and preach you a sermon on counsel because we'd be here for 6,000 hours, trying to read through each and every one of these. I'm assuming that you're literate enough that you can read this. Remember, I didn't, dream this up. I wouldn't have known the law if I hadn't gone to the Supreme Court. I'd say almost all of my education came from the Supreme Court of the United States. I just sit here and read what they tell me. Here's their 7 rules. I didn't make these 7 rules. These didn't come out of Idaho. This is what your Supreme Court said you have to do in order to get them to listen to your issue. And so, just to regurgitate a moment here, you'll notice that there's only 2 pages in this motion. And this motion it's a notice and demand for counsel of choice. It's a demand for a right guaranteed under the 6th Amendment, guaranteed by Argersinger and about 15 Supreme Court cases. It's just 2 pages. It says, here I'm demanding my right to counsel, and here's why. Now, they can sit there and claim that I've got to have a licensed lawyer or that I've got to have some kind of counsel beholden to the judge who's my adversary, but I can sit there and withstand that kind of baloney with my legal quotations. And then you'll notice there's about a 20-page or 25-page brief. That's my argument in support of my motion. This is the reasons why. And in that brief, it cites the authorities. In oral argument, your oral argument will cite these authorities. These are authorities above and beyond what you've got written in your brief. And that's really all there is to it. Go back to Lesson 7. The way you argue a brief or a motion in court, you just get up there. Remember, don't try to read it into the record because that's not going to work. He doesn't need a reading lesson. What he needs is to be edified or educated as to what this issue is about. They have statutes here in Idaho that say that only licensed lawyers can work in the courtroom, and I agree with that 100%. I think that when a man holds himself out to be a lawyer, learned in the law and hangs his shingle out and advertises in the yellow pages, he better have a license. Now, when a friend goes in to help another friend, that's another issue. You're not holding yourself out to be a licensed lawyer for profit or gain. You're acting for no money and no profit, and you're going into that courtroom to help your friend, and that's a right of free speech. So says your Supreme Court. Your Supreme Court says that's a free speech issue to go in there and then use the word next friend. I didn't dream that up. That was the Supreme Court that showed me about next friend. And they said, you've got a right to go in there and have Mickey Mouse if you want to as your counsel. Now, you cannot be compelled to have a licensed lawyer. Now, they'll always try to compel you to have a licensed lawyer. As of this date, which is May 5th, 1983, in the state of Idaho, there have been 3 instances that I know of where lay counsel has spoken in a courtroom for another citizen who's his next friend, and so far they haven't prosecuted those 3 people for practicing law without a license. We have given the Bar Association in Idaho ample opportunity. I'm available. You can haul me into court anytime you want, fellas, and I'll defend this issue clear to the U.S. Supreme Court. In fact, I challenge you guys here in Idaho. Why don't you arrest me and challenge me in the courtroom for practicing law without a license? I'd like to take that issue somewhere, but nobody wants, remember here, if there's no controversy, there's no action. I can't go into the courtroom and sue to make these guys take those statutes off the books. There's nothing I can do. I have to sit here and wait until they arrest me and drag me off kicking and screaming to the county jail and charge me with practicing law without a license before I can even take this issue to the Supreme Court of the United States. Kind of doubt whether they're going to take us on, but if they do, we'd like to challenge and take on that issue. Now, in this lesson 14, there's 2 rules here, in addition here to this jury, and I'm going to make a comment on this jury, and then I'm going to go through a little lesson here on this Rule 3 and 4 of the misdemeanor rules. I want you to remember this, that a jury under the common law is recited to us in Thompson versus Utah, which is about an 1895 case. I think I've sent that to you in an earlier lesson. And Williams versus Florida. I think you'll find that in some of these Supreme Court decisions. When you go into the civil law, that's an administrative process. Walt Mann has got a big thick book of about 1,600 pages that just goes through that administrative process like nobody else has ever gone through administrative process. You have to go through the administrative process and some of these actions in order to set your case for appeal to the Supreme Court of the United States. Doesn't mean that you want to go to the tax court because only taxpayers go to the tax court. You may or may not have a jury. If you have a jury, the common law jury is going to decide the law as well as the facts, and if they don't, you don't have a common law jury, you have an admiralty jury. And if you're being tried in an admiralty jurisdiction, then it's a civil law jurisdiction, and you're being denied a fundamental right. You need to demand your right to be taken to a grand jury. In the state of Idaho, that's under Article 1, Section 8, and in Idaho, you'd have to be taken to a grand jury to be prosecuted for a parking meter unless you had a driver's license. Now, if you got a driver's license, they do not need to take you to any kind of a jury. If you don't have a driver's license, it becomes a rights issue. And when it's a rights issue, the grand jury or the people of the state of Idaho have got to decide whether or not they want to prosecute you first, and then The jury of 12 will decide the law, and you'll have an opportunity to present your theory of the law. Now, that's the way our common law worked. In ancient times, it's the way it works today if we can ever get it reestablished. But for openers, you're always going to be taken into a Roman civil court. And you're going to be tried in the government's court, by the government's agents, by the government's laws. You are totally divorced from the law of the land, your heritage, your common law. Now, in the Supreme Court, which is the backbone and the original court of jurisdiction for our common law, will only listen to your rights issues if you can show, through your motions, through your briefs, that you are indeed not a civil law person, that you are a common law person. Now, do you see what the job is you have to do? You're presumed to be a civil law person with a driver's license in your pocket because you're driving down the street. You're presumed to be a subject to the state legislature and that you're acting in trade, commerce, business, and industry. So you have to assert your rights. You have to assert that you are a natural individual and a free man and a citizen under Hale versus Hinkle, and that you are not a corporation, that you're acting as a matter of right. Now, once you've done that, now you put all your briefs and motions in, and what are you telling this civil law court? You're telling them, you don't have any jurisdiction over me, fellers, and you want to leave me alone. Now, they won't do that. They'll probably keep prosecuting you, of course, in some, well, I wouldn't say most of the time. I'd say most of the time they'll dismiss in those cases when you're arguing law. But when you do have the driver's license and you've been filing Fifth Amendment tax returns and things like that, now you're a taxpayer. Now you're a driver. You're in the Roman civil law. Now what you want to do is to make them pay $1,500 to get the conviction for this $50 ticket. If it's a tax case, you want them to spend, if it was a good knockdown, drag-out brawl, $10,000, $12,000 in a 5-day willful failure to file trial, and drag them out all the way. Make them spend more than they're going to collect. You know, there was a fellow, I think his name is Von Ellsworth or Ellsberg, I'm not really sure. He was in this tax movement during the 60s when it was not very fashionable to be a tax protester. And I think if I've got the story right, you know, when you've heard a story 3 or 4 times, it's generally about 10% correct. So let me tell you the story. It's a good story, whether it's 10% correct or 90% correct. Put him in jail for 4 years. And just like G. Gordon Liddy, when he got into jail, he started teaching the tax strike movement. In other words, he started teaching the other prisoners in there about their rights. And pretty soon it got to be so obnoxious in there, they said, well, gee, we'll parole you, you know. How'd you like that? And, you know, everybody wants to get paroled from jail, right? Sign this contract over here and waive all of your rights. He told them to stick it where it meant the most. And no plain, I think he was pretty plain about it. And he just wouldn't leave. He wouldn't sign. And so about 4 months later, they just dismissed him from jail. They didn't want him in there anymore. And that's what you need to do. Never let them know that when they put you in jail, that they can threaten, intimidate you, and use that kind of tyranny to break down your will and your resistance. If you're not prepared to go to jail, if you're not prepared to carry through from beginning to end, you know, when you're going to leave Egypt, you're going to go across the Red Sea. That's a wilderness out there, and when you get over the Jordan River, there's a bunch of Anakims and a whole land that's going to need to be subdued. If you're not prepared for the rigors of that kind of life, then you better get out of this fight, because it's like our founding fathers, you know, they all died poor. I don't expect to die very rich. If I wanted to make money, I'd go to California and go back into the contracting business or do something constructive where I could make a lot of money, because I sure don't make it acting as next friend for some guy in the courtroom. And neither are you. But the rewards that you get from this are the thrill, the excitement, the fun, and the enjoyment of restoring a common law, biblical right that our forefathers had when they crossed that Jordan River. They had the common law there. And that was a unique and an exciting and a thrilling piece of history there for about 300 or 400 years until they got their first king. You know, those people said, well, we got to have a king like all the rest of the nations around us. That's what they told Samuel, the last judge. Well, that's all we've done, you know. What we've needed here was, well, we've got to have paper money like all the rest of the nations around us. We've got to have these graven images that we can buy, sell, and trade and speculate in. and make profit and gain. So now you got to pay income tax on these Federal Reserve frauds, and you've got to pay your dues. You've got to open up your books and records, to these meddling bureaucrats to come along and inspect you. And then you've got to carry these documents and papers when you want to travel. In the United States, we used to travel from coast to coast or any place we wanted without carrying papers and documents. Today, you got to have a whole billfold full of papers and documents or you can't move around. And I want to restore that, and that's what I'm doing this for, and I think it's a lot of fun. But when I see somebody go to jail and then they're in there for 2 days, they put up this big front and then they're in there 2 days and then they give their fingerprints, and then they just capitulate. They just crack up, like they can't stand the pressure. Why, in that case, you cause the rest of us more harm and more grief, because the next guy comes in there and they'll say, well, it'll take 2 days to break him down, see. So you've got to be tough, and if you're not willing to be tough, well, then perhaps you ought to go out and gather straw and make bricks for your masters and shut up. Okay, now the last 2 items I want to bring your attention to is take out this book on the misdemeanor criminal rules. And I want to read through here, and I want to show you, and I want to illustrate here to you what you've got here. You've got the Roman civil law here, and you've got Roman civil law rules to regulate you in an administrative process. And that's why we've got some briefs and motions on these very subjects, that we're calling this the Roman civil law, and we're demanding our common law rights. And when you take a look at this as we go through it, I think you'll understand this a little bit better. And then when the understanding is between your ears, then when you sit down to write a motion or a brief, and bear this in mind, that not every motion and brief that you're going to write can be, bought. You're going to have to think for yourself and say, wait a minute, what are they doing in this case? How are they doing it to me? And then sit down and write the court a letter. Say, hey, this is wrong. You can't do this to me. So I'm over here on page 499. This is called Rule 3 of the Idaho Misdemeanor Rules. Okay? These are the rules that they apply to you when they're using these uniform traffic citations. They don't have complaints. They don't have affidavits in support of the complaints. If you live in a place like Oregon where they have what they call the infraction rule, remember, that's not a criminal law. That's a civil issue. And the reason that it's civil and your government is suing you is because you got a driver's license and you've agreed by contract, they're construing that driver's license as your contract with the state to obey these rules. And they're just fining you. They're giving you these civil penalties in penal, they're exacting a penal clause of a contract because you were speeding or because you were doing this or that or something else. All right, so take a look at this misdemeanor rule. Number 3, page 499 says Rule 3 here, citable offenses, methods of initiated prosecution and consolidation. It goes on to say here that charging a citable offense, a person may be charged and brought before a court for any citable offense upon the filing of an Idaho uniform citation as provided by these rules. Now, do you see how you've been divorced now from the common law? No grand jury. There's not going to be a complaint. There's not going to be an information of a public prosecutor. Do you know who your persecutor is, your accuser is? It's the policeman out there on the job. He's a judicial officer and he's holding curbstone court. He witnesses an act and he says, you are guilty and I'm going to give you this uniform citation. A citation goes with the contract. That's why I usually tell them, I don't know why you're giving me this citation. I'm not subject to Title 49. I don't have a driver's license. I'm not a person who's required to have a driver's license because I'm not engaged in trade, commerce, business, or industry affecting a public interest for profit or gain. Let me stipulate to you those facts, officer. They'll look at you and go, huh? I don't understand. Yeah, I didn't sign up for the draft either. And I didn't sign up as a resident alien. Does that bother you? Are you going to give me a couple of tickets for those too? And all of a sudden, the police, they've been to the government schools. You can't blame them. All of us have been deceived. It's time that we woke up and recognized what our rights are. There's a lot of policemen out there that would like to get their rights back also, I'm sure of that. And there's probably a lot of public officials out there from the telephone calls that I get that want to stop paying the income tax. So there's a lot of good people out there in public service, and if you're one of those good people in public service that are left, see, most of the good people in public service can't stomach the swill that comes out of our government, and they leave. That's too bad. We need those people in there on the inside to make the changes that we need. So all that's left is the swill. All that's left are the tyrants who are out there conforming or using tyranny against us to threaten and let's see how the Supreme Court worded this. They said to cunningly coerce us into waiving our rights. That's what's left in government service when the good guys leave. So if there's any of you good guys that are still out there, and there's any hope of educating you at all, we want to leave you in government service. So you stay right there. Now, the use of a citation, then, is the complaint in a uniform citation may be used as the complaint to prosecute a misdemeanor, whether or not there is an arrest without a warrant or arrest pursuant to a warrant issued on a uniform citation, or a complaint and summons to appear by a uniform citation. Number C, determination of probable cause. You see the way they use words? They use common law forms, all right. They're using probable cause and complaint and information and affidavit in support of, but all they've got left is an empty form without any substance. The substance of our common law, which is gold and silver, is gone. And so now they bring in these bureaucratic regulations. They treat you the same way they treated you when you were in school. Line up because the bell rang, sit down in your seat, stand up, march, the same way they treated you in the Army or the Navy. We citizens in the United States have been reduced to the same status as a soldier or a sailor on the good ship Idaho. Nothing more, nothing less. So they still use the form, and they still use juries a lot of time, these little 6-man juries that they conned us somehow or another a few years ago. They said, well, it would be cheaper if we had a 6-man jury. And the citizens, being educated in the government school, not understanding what a jury was anyway, not understanding that the jury stood before the government and compelled the government to act pursuant to the wishes of the people. We think that government acts pursuant to our will when we vote. Poppycock. The government jumps to the whip that's sent down by that grand jury. You want to see the government agents over there jump rope to our tune, you put those grand juries back into form in your state, and you'll find out how fast those prosecutors... You won't have nearly as many people in jail. You won't have nearly as many prosecutions. You won't have nearly as many employment opportunities for public defenders and more prosecutors. We'll just eliminate about half the crime. I'll bet you that half the crime in this country is manufactured in the prosecutor's office and in our legislatures by just dreaming up all kinds of wild things like throwing people in the penitentiary out here for being drunk. We're going to throw drunks out here in the penitentiary and call them felons. Poppycock. Going on here, the determination of probable cause. In the event a defendant is arrested without a warrant or appears pursuant to a summons, or in the event application is made for the issuance of a warrant pursuant to a uniform cause that an offense has been committed and probable cause that the defendant committed it, shall be made at the time and in the manner prescribed by Rule 4 and 5. Hey, flip over here to Rule 4. You got jurisdiction, venue, and distribution of fines. All that is Uniform Commercial Code. Uniform Commercial Code applied on our rivers of tar. So you have the old law merchant, that is the expediency of buying, selling, and trading and solving uniform commercial contracts in a judge or referee. They do this in labor relations constantly, and the way that works is binding arbitration. You go into a traffic court, binding arbitration. That's what that boils down to. When you go into a tax court, binding arbitration. Okay? And under B, we've got primary jurisdiction and venue. All citable offenses shall be heard, processed, and determined by a magistrate or judge in the county in which such violation is alleged to have occurred, except that citable offenses may be heard, processed, and determined by the magistrate's division of the district court of the county to which such alleged violation is assigned or transferred under this rule. Now, under the common law, the case has to be tried in the county in which it occurred. Change of venue, of course, is a common law rule. You can move your trial if there's extreme prejudice, but look at this very next paragraph. When you and the officer, who is a judicial officer now, notice this blending now of judicial and executive capacity. In this very next comment, we're going to conveniently, if you agree with the officer, transfer this to some other county so that you can plead guilty to this violation of uniform commercial contracts, and you can pay the fine in the county to which you want to agree. Transfer of citation to a convenient county. At the time of issuance of a citation, the person charged and the officer issuing the citation may mutually agree that the citation may be processed by a court in a more convenient county than the county in which the alleged violation occurred. Well, you see what's happened to us now? We go out there on those rivers of tar. We're reduced to the status of a seaman. The judicial officer sees us commit an act, and he goes over and he holds curbstone court. He just determines that he saw the violation that was done in his presence, done in his act. You don't have the right licenses or whatever it is, and so he makes these demands upon you. And the demands are lawful and reasonable because they're contractual agreements that you've made with the state of Idaho in order to use those rivers of tar for trade, commerce, business, or industry. And the prima facie evidence of that is the license plate that you've got on your car. That's a badge on there that says this vehicle is engaged in interstate commerce and is licensed by the state and regulated thereby. Now, the policeman stops you. Don't get mad at the policeman when he says, now that I see the evidence on your vehicle, there's a license plate on there, I want to see your seaman's papers. Now do you see where you're at? Want to see your seaman's papers, your driver's license, registration, proof of insurance. Now he looks at your seaman's papers and decides that all of your documents are in order. And then he gives you a ticket here for violating one of the rules of the ship. And there is, remember, on the high seas, there is no common law rule. It's the Admiralty rules. And the court of original jurisdiction in Admiralty is the Congress and the Supreme Court of the United States. You can't have Admiralty jurisdiction in the states, and they are constantly passing Admiralty law and Admiralty rules upon us. And they can do that, evidently, because we don't have our common law rights. We don't assert our common law rights. I'm prepared to contend that even if you don't have seaman's papers or you don't have common law rights, let me reword that a little bit. Even if you are a juristic person with a driver's license, registration, and proof of insurance, I don't believe that the legislatures can pass laws in this Admiralty jurisdiction. They have to get some kind of permission or consent from the Congress. There has to be some kind of a compact between the states and the Congress in order for the Congress to delegate that authority that only the Congress of the United States has to make rules in Admiralty. Now, how they do that, I don't know. Maybe next year we'll be smarter than we are this year. I know that we're a lot smarter this year than we were last year. I know that 5 years ago we were pretty ignorant people. I used to go in the courtroom and have on my motion letterhead in the state of Colorado in the 5th Judicial District and things like that until I learned a little better. I've made all of the mistakes that I believe that a man can make in the courtroom, and I've survived them all. And I noticed that I've won a lot of cases, and all of the cases where all of our students have gone into court, so far we've won all of those cases. And as Don Turner over in Colorado said some 4 or 5 years ago when I first got started, I don't know why it is that we're always winning. You know, sometimes we'll get dismissals and we don't know why. I think it's because of the paper. Let me tell you, friends, I know that it's because of the paper. There is no doubt. Because what you're doing here is you're raising major federal questions. And these major federal questions involve the very foundation, the very roots of which these trees in our government, these agencies, our departments of law enforcement and our drug enforcement departments and our education departments, they're all built, they're all trees growing in sand, and a good strong wind will blow them over. And I think that deep down inside they know that. I think deep down inside, and I saw this happen about a year ago, a man refused to pay his registration, or shouldn't say refused, he went down to register his car and he gave him a public money order certificate, POMC, public order money certificate. Many of you probably know what those are. And it was a promise to pay him whatever lawful money of the United States that department could show him was lawful money. Well, of course, it's got to be gold or silver coin. And So he was charged, and they demanded his license plates back, and they're using these very same rules of procedure. They gave him a citation, and they brought him into the court, and he claimed all of his rights at the common law and challenged the jurisdiction. They didn't recognize that. They only recognized that this guy is a seaman. He's on the ship, he's got to be a seaman. They don't recognize passengers on these Good Ship Idaho, or the Good Ship Iowa, or the Good Ship Texas. You're all seamen on those ships. And they prosecuted him, and they found him guilty. The jury came in, and they said, well, we've all got licenses and registration, and we're slaves, so you have to be a slave, Claude. And the judge sentenced him to 6 months in jail and a $300 fine. The maximum penalty. Boy, we're going to come down on you, and we're going to make an example out of you. And this is one of those cases where I'm telling you, don't ever back down. He went to jail, and he was prepared to stay there for the full 6 months and then come out and sue everybody in sight. 42 days later, mysteriously, the doors just opened and they let him go. He spent 42 days in there recruiting students for our school. He spent 42 days in there doing just exactly what that fellow Von Ellsworth, or Ellsberg, whatever his name was, had done while he was in prison. He was teaching those people in there their common law rights. He was in there teaching them the law of the land. And for one reason or another, they decided they didn't want Claude Potts in the Ada County Jail. And they opened the doors and said, get out of here. But I haven't served my 6 months. You're released. Well, who's releasing me? We don't know. Well, why are you releasing me? We don't know. Here's your stuff. Sign here. I didn't sign when I came into this hotel, and I'm not signing to leave. They gave him his stuff and threw him out. Now, I think he's been damaged pretty severely, and I think he's going to file a major civil rights action. And that's what I want to encourage each and every one of you to keep in the back of your mind. When we get up to lesson, I think it's 27, we're going to show you how these offensive actions go. Because every time that you have a government official violate your rights, you have a cause of action and you have a remedy. You have a constitutional right to sue that government under Title 42, Section 1983. Now, here in Idaho, we have a man up in the north end of the state who filed a number of these suits, and his name I'm not going to mention, but it's, well, I guess I can. He's mentioned in the law books. It's called the famous Miller case. And this fellow Miller filed a number of lawsuits and common law liens, and he just went out and just jumped up and down, pawed the ground, bit the bushes. And finally, the state got an action against him, a civil action, and has now prohibited him from going into the court civilly without a lawyer. Now, here's the way we get around that. I am not going to file 20 lawsuits against 20 public officials. I'm going to file 1, 2, 3, maybe at the most. And then I'm going to teach you and you and you and every one of you to file 1 or 2 or 3. What we want are thousands of citizens who are going to demand their rights, and when their rights are not met with, that they're going to file an action in the court, and they're going to sue those public officials for $500,000 or $700,000 or $1 million each. Now, what that boils down to is this. You sue the guy for $500,000. If you win, you won $500,000 from him. You may never collect it, but you'll be out there diligently trying to attach his wages and take his house and his cars, and he'll wish he'd never heard of you. But the bright spot of it is, what if you lose? If you lose, he has to pay the court costs because you're a pauper, because you don't have any assets, because you're judgment proof. So what that boils down to is, heads I win $500,000 and tails you lose $10,000. Now, Mr. Bureaucrat, did you want to take me on or not? When you get to that position and you get 500 people in every county, and I don't say every county in the nation, I just say 500 people in a county, and those people routinely coming up in traffic court or routinely coming up in various other misdemeanors and coming up before your tax commission. And every time you have an action, you fill that case with a book just like this. I doubt very seriously if I paid $100 total. $200 would be max for this case. This is a felony, and I consider that a major victory. My government must have spent $1,000 to $2,000 on this case. They can't afford that. You take their money away from them, and you take their power away from them. And when you get into those courts and when you're demanding your common law rights, when you're demanding your grand juries and they don't give you a grand jury and they convict you and put you in jail and you suffer that damage that the Supreme Court says you have to suffer to create a loss, to create an action, and you get 400 or 500 of them, you know those courts aren't going to be able to function. When those courts get plugged up, when you get a number of cases working in those courts and you're suing those bureaucrats, you're going to find major significant changes in your county, like we're beginning to experience in our county. The way I see it, the eloquence of my argument will make itself manifest in the bank statements of the judicial branch and of the prosecutor's office. What we're suffering from is trial by jury. And while we're more disposed to suffer these oppressions for a time, I think there's a limit to how long people want to suffer oppression by government and trial by government and being totally divorced from our grand juries. And I want to talk about juries here in just a minute. But I want to read this motion in Lyman. Now I want you to take a look at this particular document that I've sent to you. I want to show you how tyranny gets hold in your courts and why it is that your courts are courts and trials by government and not courts and trials by the people. Read this. This is one of the most tyrannical documents I think I've ever seen come out of a court in Idaho. Comes now Bruce H. Birch, prosecuting attorney in and for the county of Payette, state of Idaho, and moves the court to instruct the defendant's attorney, agents and witnesses to refrain from offering any proof, statements, or making any statements directly, indirectly, by inference or innuendo, in voir dire, opening and closing statements, by examination, by cross-examination, or by exhibits, or by other proofs of the following. Now listen to this. The common law or equity courts of the state of Idaho and or the United States, or common law as it has developed since ancient times, and the relationship between the Constitution of the United States and the state of Idaho. I want you to notice that this is the state of Idaho versus a fellow named Don Pallett. I want you to notice that it's the prosecuting attorney, and the fellow that wrote this is Daniel G. Chadwick, who is a legal intern. I think Mr. Chadwick is going to become infamous by the time we finish spreading this document around to our courts. But listen to number 2. The number of members on the jury and functions of the jury or any state or federal constitutional requirements relating thereto, including but not limited to the development of the jury system from its inception to the present. I mean, this fellow doesn't want you, the defendant, to talk about juries, constitution, state constitution, rights. Well, when you get into the court, what are you going to talk about? You're just going to go in there and plead guilty and say, yeah, I was speeding, or yes, I did this or that. Number 3, the jurisdiction and venue of this court. So he's saying here, we want the court to prohibit Gordon or Pallett or anybody else from challenging the jurisdiction and venue of this court or of the courts of the state of Idaho or of the United States, or the historical development of the jurisdiction and venue of said courts or any other courts. And number 4, the defendant's constitutional right of representation by counsel. So they don't like our counsel issue. They don't like our jurisdiction issue. They don't like our